Thank you. I'd call this meeting of the Lancaster County Board of Zoning Appeals to order and ask the Madam Secretary, if you will, call the roll of the membership.
Charles Dees,
Here.
James Falconberry, Mark Boland, Aaron Fender, Joshua Pengel.
All members are present. Of course, we do have a quorum. The meeting will continue as the agenda states. At this time, all staff members that have a role in tonight's meeting, if you will, stand, come to the podium, state your name, your address, your duties with the county, and be sworn in at this time. Thank you. All staff members that are involved in tonight's meeting.
My name's Allison Harden, and I'm the Development Services Director.
Shannon Cato, Zoning Administrator.
Micah Garris, zoning technician.
Julie Fell, Deputy Zoning Official.
Andy Rowe, Lead Code Enforcement Officer.
If you will, everyone raise their right hand and be sworn in. Madam Secretary.
Do you all swear to tell the truth, the whole truth, and nothing but the truth?
Thank you. Thank you. The next order of business, of course, tonight is to approve the agenda. Gentlemen, you all have copies of the agenda in your possession. Do I hear a motion? Have a motion to approve. Second. And a second from Mr. Boland. All in favor? Unanimous. Thank you. The agenda is approved as written. The next item is the minutes for the November 4, 2025 BZA meeting. Are there any changes, additions, deletions? Hearing none, do I hear a motion? Have a motion to approve as written, correct? Second. All in favor? It's unanimous. Thank you. It is. They are approved. We'll move on to item 8. Has the staff made it possible for all the applicants or appellants to receive information of this meeting?
Yes.
Thank you. Papers are sticking together. Hold on. Have all adjacent property owners within required limits been notified?
Yes.
Was there a notice of this meeting published in the local newspaper to include the meeting place, the time, date, and the agenda?
Yes.
Is there a copy posted in the lobby of the administration building?
Yes.
And this, when it says, is there a copy, it's referring to the agenda.
Yes.
The Board of Zoning Appeals have duties that are pretty specific, and they're within 3 specific areas. First is the administrative review, is an appeal of an order or a decision of the administrator that has alleged errors. We have the power to grant a variance, and it's given to the Board of Zoning Appeals by the state of South Carolina. Variances may be granted when strict application of the zoning ordinance would cause unnecessary hardship, and the granting of the variance would not cause substantial detriment to adjacent properties or public good. And special exceptions are permitted, uses within a zoning district, but require a public hearing prior to granting final approval. There are a few instructions that I don't often have to give, but tonight I will. Anyone speaking will come forward to the podium, speak into the microphone, state your name and address, and be sworn in. All information is recorded for the record. For the purpose of clarity, staff will make their report first. The applicant appellant will speak next and will also have an opportunity for a rebuttal after citizens' comments. Citizens who wish to be heard will speak third, please, and in some cases, fourth. Citizens who wish to be heard will speak, and please limit comments to no more than the allotted time. Per Section 6.b of the Rules and Procedures, that time limit is 4 minutes. At this time, we will hear a statement of matter on the first item to be heard, which is BZA 2025-2088, the Nuns Boron. Okay.
Thank you, sir. Can you click on that? Thank you. This is an application by Emily Brown Law, LLC, on behalf of David and Tamara Boren, who live at 7940 Green Pond Road, to appeal a home occupation permit granted to adjacent property owners George and Jessica Nuns at 7965 Green Pond Road. To give you an overview of the property and the area of the request, this is the area known as Green Pond Road. This area is past the paved section of Green Pond Road and is made up of 5 properties. The appeals is for the Nuns home occupation. The Nuns property is outlined slightly in blue on the left-hand side of your screen, and the Borons who filed the appeal, their property is on the right-hand side, labeled as such. The zoning district for the properties, both of them, is rural neighborhood, an RN. There's a timeline associated with this application that I wanted to review with you. It is on the first page of your staff report, and I appreciate your grace while I read out this for the record. On May 12th, the code, all of this happens in 2025. On May 12th, the code enforcement staff received a complaint from Tammy Boron regarding a home business being operated on property owned by the Nuns. The complaint stated that the Nuns were, quote, running a home manufacturing business in a rural neighborhood with an implied easement of our private driveway with heavy commercial delivery trucks daily, damaging our driveway and property, end quote. On May 13th, code enforcement staff made a site visit and physically issued a notice of violation to the owners of 7965 Green Pond Road, instructing the owners to, quote, come to the zoning department and get a home occupation permit, unquote. Staff noted there was an accessory structure on the site. Records indicate that accessory structure had been there since 2000. On May 16th, George Nuns went to the zoning department and applied for a home occupation permit as instructed. The address for the home occupation permit was changed from their residence address at 7965 Green Pond Road to the address for their accessory building, which was given 7961 Green Pond Road. The description of the home occupation was internet golf sales, as Mr. Nuns embellishes golf clubs through online transactions. He receives golf clubs, does modifications to them, and sends them back. As part of the application, sections of the Lancaster County Unified Development Ordinance are provided on the application form, and applicants are instructed to read and initial those sections. Code references on the application include general standards, additional standards, uses prohibited as home occupations, and grandfathered home occupations. The applicant initialed each section. The same day, Ms. Boron called the zoning department and received an update on the violation. Between May 21st and 22nd, after reviewing the application, staff issued the home occupation permit for 7961 Green Pond Road to George Nuns. The conditions included limits to the occupation is for office use only, for online sales and paperwork. Mr. Nuns paid the home occupation permit fee of $75 and received the home occupation permit. The complaint was marked resolved on May 23rd. On June 10th, between June 10th and 11th, Ms. Boron calls the zoning department to ask about the complaint and about road issues. Zoning and code enforcement staff left a message on June 11th updating Ms. Boron and advising her that she could file a Freedom of Information Act request to receive copies of all the files. On July 10th, 2025, a FOIA request was received by staff from the Borons, and on August 1st, 2025, all materials from the FOIA request were delivered to the Borons. We have digital certification of that. On September 5th, 2025, David and Tamara Boron applied for appeal to the decision to issue a home occupation permit to George Nuns 35 days after the receipt of materials relating to the permit.
Quick question.
Yes, sir.
Back up to the other slide.
Yes, sir.
There we go. September 5.
Yes, sir.
Appeal filed 35 days after receipt of permit information.
Yes, sir.
Do we not have a 30-day limit based on the UDO?
We do. Part of the
Why
reason.
is this 35 and accepted?
The reason it was accepted is because we did not know at the time of the application that the applicant had received a copy of the application or the home occupation permit. During our staff report and review, we found that the applicant had filed a Freedom of Information Act request and had received that, which then kicks off the 30-day count. Typically, when we issue home occupations, we don't issue copies of them to the neighboring properties. That is not part of the process. So if another home occupation were to be appealed in the future, we would take it on its face value unless we found that it had been given a copy. So the 30 days kicked off once the Borons got the Freedom of Information Act.
That's fine. Thank you.
Yes, sir.
Just slapped me in the face when I saw 35.
Yes, sir. The applicant's legal team provided a narrative of the issues, and staff has summarized those into 5 main points, one of which is that there was an incorrect address on the application. There's incorrect square footage listed on the home occupation application, the shared driveway issues with Green Pond Road, commercial traffic and speeds and the impact on the access point, and the use of more square footage than allowed. We'll address each one of these from staff's point of view. The address on the application, the applicants said that they were using an incorrect application. However, the property records and the Lancaster County 911 map indicates that there are 2 legal addresses on this property. There is no rule or record that you can only have 1 address per property. So this is both on the property tax records and on the E91 GIS that the outbuilding is 7961 and the home is 7965. There was also a report that the proper square footage was not indicated on the application. There are 2 sections in the application where square footage is asked for. One is what is the square footage of the building where the home occupation is going to be held, and the other is what is the total square footage of the home occupation proposed. The total square footage of the building is 1178, and that was correctly indicated on the proper section of the application. The 475, which was the intended area for the home occupation, was also listed in the proper place on the application. Regarding the shared driveway in Green Pond Road, the applicants in the letter often said that the neighbors were using their driveway. We did deed research on the properties. The properties at one point were one piece of property. I believe we gave you a chain of title relevant to that, and discovered that when this was subdivided originally into this design that's on the screen now, there were 4 lots created, and particularly the two lots that created both, that ended up being in the property of the Borons and the Nuns, had specific language regarding the easement on their deeds. So for the Nuns property, it specifically says that the grantor grants unto grantee, his heirs, and assigns a right-of-way for ingress and egress to and from the above-described property to Green Pond Road extension, which would be the point at which the Green Pond becomes public, and is more accurately shown on the above-referenced plat. The image on the left is the above-referenced plat that created the subdivision. I believe it's in 1998. So the Nuns have a clear use, an easement for ingress and egress along that shared property line between the Nuns and the Borons. For the Borons, their deed has a little bit different language. Their deed says that grantor is reserved a 15-foot wide right-of-way for ingress and egress extending along the western line of said property for a distance of 370 feet. So because we're not here to debate whether the Borons actually have right-of-way along the entirety of their street width, because it's more than 370 feet or not, what I do want to indicate is that both property owners have a 15-foot on each side of that property line access, ingress and egress. That is shared. It's a shared 30-foot shown on the plat circled in red. The plat was recorded with each one of the properties, indicating that that 30 feet had 15 feet on either side, and it's shared between the property owners. For commercial traffic and speeds and impact on the access point, staff didn't have any data on that and didn't have the availability to do that. We're going to defer to Mr. Nuns, who has information regarding his deliveries. I believe that the applicant also provided some information from their security camera. And as far as speeds and the like, that is a public safety issue, not a zoning issue. So we don't have anything to say on that. As far as the use of more square footage than allowed, Mr. Nuns was asked to provide pictures of his area that is in his garage that he uses for his workshop, and these are the pictures. The staff measured them by scale and discovered them not to be more than 500 feet. And so for those reasons, staff is not in favor of the administrative appeal being granted.
Thank you. At this time, I'll call the public hearing citizens' comments. They need to correct this. Does the applicant have anything they'd like to offer at this time? Pardon me? Yes, sir. Please come to the podium, state your name and address for the record. You will have up to 8 minutes to make your comments. Pardon? Let them get through up there. If you will, raise your name. You give your name and address for the record. Raise your right hand and be sworn in.
Tammy Boron, 7940 Green Pond Road, Fort Mill, South Carolina, 29707.
Do you, Tammy Boron, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
Thank you. Now you have up to 8 minutes to make your comments to the Board of Zoning Appeals, not to the audience. And please keep your comments on the record for the item that we are hearing.
Yes, sir.
Thank you.
Thank you. Good evening, and thank you for allowing.
Please pull your microphone around.
Sorry.
Is it on?
Can you hear me?
Okay.
Just speak closer. Can you hear me?
I hear you now.
Okay, sorry about that. Okay, good evening, and thank you for allowing me to speak to you this evening. I want to provide a clear overview of why we are requesting Mr. Nunn's home occupation permit to be revoked. We are not here in anger, but in the spirit of fairness and accountability, seeking to protect our property, our animals, and the integrity of our rural neighborhood. We moved to Indian Land a little over 2 years ago to establish a small farm where we could keep our horses and live peacefully in a rural neighborhood. After settling in, we noticed a constant flow of delivery trucks to the Nunn's home. When his wife mentioned that Mr. Nunn sells Scotty Cameron putters on eBay, I looked into whether he had the proper permits and how he was able to use our easement for a commercial operation. The South Carolina Secretary of State's website shows his business, Restoration Golfwear LLC, registered at 7965 Green Pond Road, filed in May of 2020, 6 months after they moved in. Because this address is outside Fort Mill town limits, I contacted Fort Mill. They said I needed to contact Lancaster County Zoning, where Mr. Rowe confirmed that Mr. Nunn's did not and had not never held a home occupation permit. I expressed concern about the scale and the nature of the business and the commercial use of an easement never intended for that purpose, which does not meet the criteria for a home occupation in a rural area. In May, Mr. and Mrs. Nunn's were issued the permit, which shocked us. They were aware the easement is a private drive when submitting the application. 7 months earlier, on October 3rd, 2024, Jessica texted me that the county had confirmed this, stating, quote, "The entire strip is considered a private drive," end quote. This shows they knew the easement status and knowingly provided inaccurate information to the county. And this is all in your packet as well, this text, for example. Our previously friendly relationship, we were very friendly. We exchanged Christmas gifts. We talked fairly often, but we did have a very friendly relationship with the Nunns. But yes, it did become strained when we asked him to sign a maintenance agreement and share repair costs for the damaged easement, including paving the upper portion to prevent gravel from entering the pasture. He refused both. Last spring, one of our horses was severely injured, or had severely injured a tendon. He couldn't walk, and the veterinarian could not rule out gravel in the pasture as a contributing factor. The horse required 6 months of intensive and costly therapy, and the easement's current condition continues to pose an ongoing risk to our animals. You can see the veterinarian's report as well. Horses, if you know horses, horses can spook at the slightest noise or movement. Yet Mr. Nunn's frequently speeds past while I am working with them almost every evening, Monday through Friday, creating a serious safety risk for me. The sheriff cannot issue citations on private property for speeding, but told him to slow down and suggested speed bumps, which we installed and later removed per fire department regulations. Despite the speeding, property damage, and commercial traffic, it continues unabated. Because of his business, we've lost safe riding conditions. Green Pond Road is extremely narrow. There are even signs saying narrow road, not built for commercial traffic, and has a 15-mile-per-hour speed limit. After several near misses with speeding drivers while riding our horses, it became too dangerous to ride. Two vehicles cannot pass without one going off the road. We ultimately had to ask FedEx to stop delivering due to their speeding and reckless driving. Once again, these photos are in the packet. According to Pitney Bowes Parcel Shipping Index, the average American household received 167 packages in 2024, about 3 per week. The nuns receive roughly 21 per week, totaling 1,008 deliveries a year, not including the FedEx ground shipments we asked to stop. This level of traffic is plainly incompatible with a home occupation in a rural neighborhood. How does a permit approved for office work / paper sales, I believe it reads, how can that generate over 1,000 deliveries a year? He has not contributed a single dollar toward maintaining the easement his operation has damaged. We are law-abiding citizens who value honesty, fairness, and property rights, and allowing this operation on our taxed property undermines the rural character zoning laws are meant to protect. We have lived in 7 states and abroad and have never encountered anything like this. Some neighbors see us as, quote, the new residents causing problems, when all we are doing is protecting our property and following the law. Anyone in our position would feel the same. We simply want to live safely and peacefully without our property being damaged or devalued by a commercial operation that should have never been allowed. The home occupation application requires the applicant to certify residency at the listed premises and comply with all provisions. Mr. Nuns has failed to do so. Under the regulations, any violation voids the permit. Given his repeated violations and the serious impact on our property, animals, and the health of our family, I respectfully urge the committee to revoke his home occupation permit immediately. Thank you for your time and consideration.
Thank you. Now comes time for, excuse me, go right ahead.
Hello, my name is David.
Knew you were coming up. I didn't,
Sorry, yeah, I got it. You gotta swear me in.
slid by me. I forgot.
Yeah,
My
David-
mind is old.
That's okay. Yeah, David Bourne, 7940 Green Pond Road, Fort
Got to
Mill.
be sworn in, please.
Do you, David Boron, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
Yes, I do. So good evening, members of the committee, and thank you for serving the community like you do. We appreciate it. So property rights fundamentally mean that an owner controls how their land is used. As you know, we reserve the right to exclude unauthorized use and to require that any easement or shared driveway access be strictly limited to the purposes for which it was originally granted. In this case, ingress, egress only for residential use, not expanded into commercial or excessive use in any way, shape, or form. For example, since May 2025, our gate and easement cameras have recorded hundreds of deliveries, many of which are speeding by FedEx, UPS, Amazon, Postal Service vehicles, fleet drivers from Amazon. Oftentimes they'll also rent like budget vans, so you'll see those too. and they're crossing nearly 300 feet on our property going straight to 7965 Green Pond Road. Deliveries and neighbors use only 15 side of the proposed easement, placing the full burden on our property. So the 15 feet out of the 30 is all on our side. That's the only side being used, nothing else. And in the packet, I put a kind of an expanded picture of the plats. You could see that, and a picture of the private drive. We have also enclosed date and time logs from our recordings of delivery traffic from 7965 for the past 3 months, and our past 2 months in our packets. For example, just last week, there were 17 deliveries to 7965. November 28th, 4 deliveries. UPS, Amazon budget van, Amazon truck. It's in the packet as well. Also, Postal Service special deliveries. They'll come down and go straight to their home. It's just constant. The next day on the 29th, 3 more deliveries came down. Again, all captured and recorded by our cameras and logged, date and time stamped. So after we purchased our farmhouse on 7 acres just over 2 years ago, we made significant personal investments, and we've transformed it into a very attractive equine property that reflects the rural character intended for this area. Thankfully, our farmland and rural land use are protected by ordinances in this county, and we certainly appreciate that. But unfortunately, that rural character is now being compromised. One commercial business operating off a private drive has materially diminished the quiet enjoyment of our property. The increased noise, dust, traffic, and shared private drive erosion resulting from this commercial business are incompatible with the intended use of this rural land. To protect our home and animals from these impacts, we have been forced to invest in controlling gravel runoff into our pasture by adding spoil piles, just piles of dirt, basically, that's what those are, installing a 265-foot privacy fence, only necessary to protect our property. So it was a lot that went into that. We also had to expand some culverts to direct some of the gravel runoff as well. We've also had to restrict access to certain neighbors using our private drive because they contributed to the nuisance and degradation of our private drive. It was already distressed, and we didn't need any more. This is not a mere inconvenience. It threatens the very character and purpose of rural residential district and our farmland. Before I wrap it up, it's important for you to know, I think, and I put this in the packet, the business ownership and nature of the home occupation. Tammy went through this a little bit, but I went into a little bit more detail in regards to Restoration Golfwear LLC. That's a company that is owned by Georgia Nuns and headquartered at the same address, 7965 Green Pond Road, and that's in the packet. The business name, Restoration Golfwear, also appears on Facebook pages as well. Also in the packet, and also in there, in his own words, he says, we specialize in making the very best restored to like new and sometimes better than new putters and irons. So there's obviously, that kind of, it's more than online sales. There's work going on there, which is great, but I don't think it's the right place. So Georgia Nunn actively sells golf clubs and related products through online platforms. eBay username Golf Custom Solution 15. Impressive, 22,000 golf products sold and shipped in the last 10 years. That's as of 11/28. It's verified on eBay as well. I put a picture in there. So 22,000 products. Pretty good. So clearly, a rural neighborhood is no place for a commercial operation like this. We don't think so, at least. Therefore, your decision tonight to revoke the home occupation permit belonging to George Nuns is a critical step in restoring our property to its rightful use and preserving the integrity of our farmland. We appreciate you listening, and thank you for your consideration.
Good evening. I'm an attorney here representing, my name is Emily.
You have to be sworn in too, like all the rest.
Thank you, sir. Emily Brown, 454 South Anderson Road, Suite 211, Rock Hill, South Carolina, 29730.
Do you, Emily Brown, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
Yes, I do. Thank you. I thank you for your time. I just wanted to kind of follow up with what the Boron's comments. Essentially, the UDO defines a home occupation use as a small and quiet business that is generally invisible from the road frontage. It also prohibits generating traffic that is in greater volumes than one would reasonably expect in a residential neighborhood, and commercial vehicles shall not access property from a shared driveway. And while I realize that the plat shows a 30-foot easement, and that's all well and good, the fact of the matter is, and I have a couple of pictures, that there's really not a 30-foot driveway out there, and that simply is not being used on anyone's property except for a small gravel driveway along the Boron's property.
Please hand those to the clerk.
And as the Borons have shared, there are far more than vehicles coming down this driveway than one would reasonably expect in a residential neighborhood, especially a small driveway that is really only accessed by 3 homes and some vacant lots. And it's causing ruts, erosion, gravel, and commercial vehicles, a fair number of commercial vehicles are coming down this driveway. The main issue here is the traffic. The UDO does prohibit home occupations that generate a significant amount of traffic for a residential neighborhood and have commercial vehicles coming and going down a shared use driveway. And so while nobody here is saying that, the Borons should not have this business, I think the issue here is the location and whether this is a business that's appropriately operated out of the home. And based on the plain language of the UDO and the facts that provided by the Borons, they contend that this is not the appropriate location and the home occupation permit was issued in error. So we're asking that you just find that the staff erred in issuing this permit and revoke it.
Thank you. At this time, I will pardon me? Mr. Nuns, I didn't see him.
You're good.
Please give your name and address for the record and be sworn in.
George Nunn, 7965 Green Pond Road.
Do you, George Nunn, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
I'm not going to address all the fallacious claims because I don't have time. I will say that I am guilty of having a wife who spends a lot of money on Amazon. We do get quite a bit of deliveries. The only other thing I'd say is that the neighbors, you can see who the neighbors came to support and who they didn't. And also 35 days, 5 days late on the appeal. That's it. I don't want to waste your guys' time. Thank you.
You. Now, am I missing anybody else? Hearing none. The Board of Zoning Appeals, as I do have a public hearing sheet. So we are in public hearing at this time. No one has signed on this piece of paper to speak tonight. So we will consider ourselves out of public hearing at this time. I just closed it, my friend. Didn't you hear me? I'm sorry. I'm not going to open it back up. Not on this sheet. This is the one from last month. Then you come right on up and speak. I've got that somewhere in this stack. I've only got about 300 pages so far. Go right ahead. I'm sorry.
That's okay. Tyler Dolge, 7741 Green Pond Road, Indian Land, South Carolina.
I'm sorry, can you state your name again?
Tyler Dolge?
Tyler Doge?
Correct.
Do you, Tyler Doge, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
I do. Thank you. I just wanted to approach you folks to just let you know we could have had a whole bus full of the people on Green Pond Road. Everybody's very upset by all of this. My father-in-law is here. They call him the mayor of Green Pond Road. He literally drives around and will clean people's yards. I don't know if y'all are married, but I probably get 50 Amazon deliveries a week myself. They actually scared the UPS drivers away. They scared our mail lady away. They bought the last end of property, which were close friends of ours, and they have done nothing but terrorize the neighborhood. Heavy police presence, always. They've called the police on me, on him. They've called the police on everybody for everything. They say we're not even allowed to go to our friend's house anymore. And we can go to our friend's house.
Okay.
Thank you.
Thank you. I do have one more name that was on the sheet from last month. Tyler. That was you?
Yes, sir.
Mark. It looks like Mark something. Okay, he's not here, so we will now close public hearing completely. And hope we don't have to open it back up. Since there has been people speaking, the applicant has an opportunity to rebut what you've heard outside of your own conversation. Is there any rebuttal? Hearing none, we'll move on. All the speakers that had signed have been heard, so this portion of the case is closed. Board members, you have an opportunity at this time to question or to ask questions of the applicant. Yeah, I'll get to the staff in a minute. Is there any questions from the board members for the applicant? Do we have any questions from the board members for the staff members? Mr. Bangle.
Who is responsible for maintenance and upkeep on the driveway, seeing as it's private?
Private
It's
entities.
not county maintained, correct?
It's not county maintained. The private entities are responsible for that. Yes, sir.
Ms. Harden, if you will. The driveway that they keep talking about, is that not considered an extension of Green Pond Road to service properties back behind the two of them?
We did
It
research.
shows me in some paperwork that I've read through in this 200 sheets that it is considered and will be an extension of Green Pond Road.
We did research on that because we saw that as well in some of the older deeds. What we found from information gathered from neighbors in the area by my staff was that the road had at one time extended all the way up through the vacant land that's just north of this,
Right.
toward the state line. And there had been a informal extension of Green Pond. At some point, the bridge across the creek had broken down, and the road that was never replaced, so the road became a dead end in that area.
Right.
While it is said in the deeds of the like that the road would become an extension, the road was never dedicated to the county. The county never accepted it, so it remains as a 30-foot easement, on 15 foot on either side of the center property line.
Okay. And if I saw it correctly, everybody listen good. In the copies of the deed where it showed the easement, 15 foot basically on each side, there is no statements on either of the two that I saw that gives anybody a reason to maintain the property, to maintain the driveway, other than the fact that half of it's on their property. I think the question in my mind is why? If I'm going to give you 15 foot of my land to use as a driveway, then we're going to take care of it. But this case does not have that.
Correct. There are several like that out there, where you have to work together as neighbors.
Right. Either that or somebody put the whole driveway on their own property. All right, thank you, ma'am.
Yes, sir. Yes, sir. Yes.
No, he can use the whole
Yeah.
30.
If it was split 15-15 down the middle, then you would have people driving on the wrong side of the road half the time. It's the easement is recorded in the deeds and on the plat. The plat says 30 feet, and it shows that it's shared. And with the exception of the the boron side, where it actually gives a limit to how far it goes, the other ones are not given a linear limit. Right. And we have not found one, but we have very few records available to us that have been recorded at county level.
So the property line is technically in the center of the easement.
Yes, sir.
So half of the easement is on their property, half is on theirs.
Yes, sir.
But either one of them has access to the entire 30-foot easement. Unless there is an attorney in the house that can tell you. All right, anything else? Any members? Yes, sir, Mr. Mark. Okay, if the applicant would, either one of you, come forward to the podium.
Yes, sir. Yes, sir. So I go back, what happens, that's Arlo, so it drops into a file system every month, and then, which is then date and time stamped. So that's just me taking it off of the recordings and putting them on the paper for you. That's all that is. I couldn't bring recordings in, it would take a long time. Yes. Yeah, okay, yes, yep. Those were phone. Those were on the phone when we were outside. And the reason we took those and put those on there is because, again, the 30-foot easement, 15 is on our side, and those show that. So all the traffic is only on the 15 of our side of the property, none of which is on the other 15 side, 15 feet, all of it. So all the traffic, the ingress egress for the neighbors, that's no problem. It's allowed. But the commercial traffic is only using the 15. The neighbors are only using everybody's using the 15 feet on our side of the property. So that's what those show. Yes, sir. Yes, sir. Yeah, that one is, but we also took a picture on the phone of that one. Video as well. It's photoed and videoed is what she's saying. She's reminding me to say videos, which is important. Yeah. Is that it? Okay.
Thank you. Any further questions for staff or Ms. Harden? Hearing none. The floor is open for discussion among the board members. And I think you made a good point with the list of vehicles in and out. I noticed a whole lot of them were speeding. Most of those were either Amazon, UPS, or the post office. And those are the people that need to be notified about speeding, not us. Pardon me? Microphone. I'll forget about it. Keep reminding me. But I quit. Anyone else? Hearing no further discussion. Per UDO 9.2.14C, we have conducted a formal review and action is required. Board members, do we have a motion to reverse the original decision or permit, affirm the original decision or permit wholly or in part, or modify the contested decision of the permit, or continue this to a later meeting? You've heard the request. Do I hear a motion? I will wait for a motion until it's tomorrow. Per the UDO 9.2.14.c, the board has conducted a formal review and action is required. Board members, do we have a motion to reverse the original decision or permit, affirm the original decision or permit wholly or in part, or to modify the contested decision or permit, or continue this to a later meeting? Do I hear a motion? I have a motion from Mr. Taylor to reverse the original decision. Do I hear a second? I have a motion from Mr. Boland. All in favor? Or is there any further discussion? Hearing none, all in favor of the motion to reverse the original decision or permit, will please vote by the usual voting sign with the raise of the right hand. We have All opposed to the motion will show the same voting sign. The motion to reverse the decision or permit has failed. The permit will stay in place. At this time, with the motion approving the permit and leaving it in place, staff, do you have any further comments concerning this?
No, sir.
Then there will be an order formalizing the decision. It will be issued to the interested parties within 30 days. And if it's prepared quick enough, I'll sign it quick enough, you'll get it back in less than 30 days. All right. The next item on the agenda is variance request 2025-2354 Bale. I hope I pronounced it right. Is that closed? Good. All right, Ms. Harden.
Yes, sir.
You're up.
This is an application for a variance from UDO Section 871 and 872, stormwater conveyance systems to allow construction of a pool encroaching into the drainage easement on property at 6512 Ancient Way, Indian Land. Overview of the property. The property is outlined in blue on the aerial photography on the screen. The request for the variance is at the same location as the applicant's address. And the zoning district for this is medium density residential with a cluster subdivision overlay. Relevant to this request is the details on the overlook at Barber Rock. Barber Rock was created in 2014 and started development in 2015. The cluster subdivision overlay provides for reduced sizes of lots and setbacks and the like when an applicant proposes or pledges to set aside a larger section of open space. And that is seen in our UDO as being an attempt to keep rural feel in residential areas. When this was designed, this was prior to the 2016 update, which is what we're currently under now. So the zoning standard back then was called, the district was called R15P. And the setbacks, as you see on the left-hand screen, there were 40 feet from the front, 20 feet from the side, 25 from the rear. Minimum lot width was 130 feet. That was mostly due to, at the time, there was a lot more septic tank development going on, and that's required for septic tanks. And minimum lot size was just under half an acre. For the cluster overlay that was given to the overlook at Barber Rock, the front setback was reduced to 20 feet. The side setbacks were reduced to 5 feet. The rear setback was increased to 30 feet, in part because of the drainage in the back. And the minimum lot width was reduced from 130 to 50 feet, and the minimum lot size was reduced to 5,000 feet. The property, as proposed in the packet, is that they would like to build a swimming pool in their backyard, and there is a 20-foot stormwater drainage easement running through this property and the ones adjacent to it. Did my best to put a highlight overlay showing you where the 20-foot easement is on the sketch that was given to you in the packet. The applicant has signed a drainage easement liability statement accepting impacts resulting from this encroachment if it is granted. Standards of review for a variance are in the UDO. These are ones that we amended last year to bring it more closely in line with the state code. So these are exactly from, as written in the state code, that there are extraordinary and exceptional conditions pertaining to this particular property, that these conditions do not generally apply to the other property in the vicinity, that because of these conditions, the application of the ordinance to the particular property would effectively prohibit or unreasonably restrict the utilization of the property, that the authorization of the variance will not be of substantial detriment to adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. These are the four specific, and there are two general ones as well, that you do not create a use by variance that wasn't there, and that the variance is not granted in order to increase a monetary value or to make a profit. For the extraordinary and exceptional conditions, oh, and by the way, the staff report goes by each of these and gives staff's opinion on this. The applicant will then have the opportunity and in their application has answered the same questions, and then it'll be up to you to ask us questions and then deliberate. So for staff's opinion on the extraordinary and exceptional conditions, we disagree. The drainage easement that is impacting the particular property, which is the top right-hand side on this slide, also goes down past the neighboring lots as well. There are lots across the street that have that drainage easement, and I hope that that didn't come up the way it looked like it did. But we have in your packet can you hit the space bar, please, see if it'll go? In your packet, we have, a copy of the plat, preliminary plat dated January 14th, 2015, which showed that the 69 of the 125 lots proposed had drainage easements. In the plat, for your reference, Vintage Avenue was eventually changed to Ancient Way, which is where the property is located. The lot numbers are the same, but the street name changed. And the stormwater systems empties into Sugar Creek. To give you an example of this area, the applicant's lots is one of those in the yellow. The ones in yellow are subject to rear drainage easements. The ones in blue are subject to side drainage easements, and the ones in green between the two are subject to both side and rear drainage easements. So in our opinion, this does generally apply to other properties in this area. The next one, the effectively prohibit and or unreasonably restrict the utilization of the property. The neighborhood has been built out with houses. Beyond that, we have nothing else to say about whether it would effectively prohibit or unreasonably restrict the utilization. The property is under utilization now. As for the substantial detriment to adjacent property, our Stormwater Division has chimed in with comments regarding how stormwater drainage works, where the stormwater drainage channels and drainage easements are there to convey water from the neighborhood to the systems out to Sugar Creek and beyond. We can't predict what will happen in those drainage easements. If we get a very heavy rain, or if something upstream is clogged, then you can have different issues in drainage systems. There could be damage, there could not be. It depends on the rainfall, it depends on the design, it depends on a lot of things. But we cannot absolutely say without a doubt that there would not be damage or detriment to neighboring properties. And I'll show you in the next slide an example of what I'm talking about. If the swimming pool requires fill to be built into that easement area, fill takes up storage space that is supposed to be there for stormwater. When you move fill into a stormwater channel or a floodplain or the like, you're essentially pushing the water elsewhere. when you put fill into that area that's supposed to hold water, it will either push it away or push it further out. It may slow the flow down and push it back upstream. It may cause a hole downstream. This is an example from the National Flood Insurance Program's guidance document on the effects of fill on a floodplain, where properties that are across a channel from a fill project can be negatively impacted by the fill over time. For this particular example, I took a sketch and modified it. On the left-hand side before the fill, you have the right-of-way at the bottom of the screen. You have the drainage easement going between the two houses and the stormwater pond in the back. If, for instance, the house on the right-hand side after fill, or down to the two houses, if the house on the left put in fill adjacent to their house to stabilize the foundation, for instance, the water then goes across and goes outside of the drainage easement on the neighboring property and can cause further damage up and down the stream for there. If there's debris or things caught in those channels, then they can also become a dam and hold water back toward the street. So for these reasons, staff does not support or cannot recommend the granting of the variance.
Thank you, Ms. Harden. The applicant, do you have anything you'd like to offer? Come to the podium, please. State your name, your address, and be sworn in.
Johnny Abale, 6512 Ancient Way, Indian Land, South Carolina, 29707.
Sorry, can you state your name again?
Johnny Abale?
Johnny Abale. Okay. Do you, Johnny Abale, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
Thank you, Board, for hearing our case tonight. We appreciate your thoughtful consideration. So just a couple of factors in terms of the hardship. I think standard was we provided a couple of documents. First, the obvious, we accept all liability, waive liability from the county, the HOA. If any issues were to arise, the county or the HOA needs to access that area of our yard to get to the drainage pipe. Again, we accept the full responsibility of costs, et cetera, to making that, accessible to the county. So first and foremost, we do accept that liability, and I did submit a waiver of liability also. In regard to the hardship, we feel it's a slight encroachment into the easement. I think about roughly a couple of feet. Not the entire easement as well. I think based on the sketch of the diagram, it shows you what area we're going into. We feel with the way our yard is shaped, there is a large slope. The easement does run directly in the middle of our property, so it's not towards the back or front. It's right in the middle. So it does limit in terms of depth, location, permanent structures, things we can implement for our children. We have 2 young children, young daughters. Just want to have some fun in the backyard, swimming pool. We think it's a modest update to our house. With that, again, slight modest encroachment, we think it's reasonable to look at something like that. So from that point of view, while yes, that some of our neighbors do have the same easement, not everybody in the neighborhood has that easement. We have other friends in the area who have built pools pretty freely and not have to worry about those type of situations. So, there is some quote unquote extraordinary prevention of the utilization of our property in that respect due to the easement and the large size of it. That is the liability. I did have some notes, so I apologize, just looking over my notes. Bear with me a second. Again, we understand it's the HOA's. The HOA has approved all our pool plans as submitted. They understood the drainage easement. They saw what we were encroaching on, and they gave us the okay as well, obviously with our consent on the liability aspect of it. Just as a side note, we do have a pool in our development that is used by the neighborhood. Again, going back to we have a young family. It's not always the best. We don't feel like for our children, you have adults, college kids in there, and they're going to do things what 20-year-olds do. So We want a little more privacy in that respect, like I said, and that's what led us to the decision to do something in our backyard. It's a pretty substantial financially, so we're willing to do that, again, for our family, for our children, and again, just for some slight improvement and some enjoyment. Thank you for your time. I appreciate your consideration on the matter.
Thank you, sir. And it is now time for public hearing. And Mr. Abali, you just finished. You want to speak again? That's fine. Thank you. Just don't want you to think you were overlooked. I've done that in the past. So at this time, we will consider ourselves at a public hearing. And I think Mr. Abali has done a good job with his rebuttal. So, do you have any other rebuttal you'd like to offer? You would have to come to the podium. Please state your name and address for the record and be sworn in.
Courtney Abale, 6512 Ancient Way, Indian Land, South Carolina, 29707.
Do you, Courtney Abale, solemnly affirm that the testimony you are about to give is the truth and nothing but the truth?
Yes. Hi. So I just wanted to say, when we started this process, we knew about the drain. We didn't really realize that when we bought the house, actually, that we couldn't build anything in there. Not sure if we ever signed anything about it, but I guess we were just not really aware that you couldn't build a structure in that, any part of that easement. But I had called, when we started this process with my pool contractor, I had called zoning department, spoke with a gentleman on August 7th. I don't know his name, but I told him the situation, how we wanted to encroach on it by about, I think it's like 4 feet. And he told me that Lancaster County doesn't own this, they don't own the drain, they don't care what we do, and basically told me, go to your HOA. So I said, great, okay. Next day I filed the HOA letter, to get it approved through the HOA. I gave you guys the letter. I did that on August 8th. They came back, they approved it, and just basically said, anything happens, we're responsible for it. Both neighbors on our right and our left, we've made aware. They gave us their verbal consent that they're fine with it. I don't have it in writing. We can sure get it in writing from them. And yeah, our pool builder, he thinks it's just a small encroachment. Said they're going to be very careful, and we're pretty confident that it'll be okay, and that we'll take responsibility. And the thing about the pool, our neighborhood pool, like my husband was saying, we do have a neighborhood pool. There's been a lot of drama there with neighbors and fighting about the hours and parties, and they get the police called a few times. So it's just kind of drama, and that's why we decided that we just want to build in our own backyard. That's it. Thank you.
Thank you. I think everyone that wanted to speak has spoke. So the public portion of this case is now closed. Board members, do you have questions for the applicant? Yes, sir, Mr.
So what's going to be encroaching into the drainage way? Is it the actual pool itself, or is it going to be like a concrete walkway around it?
Would you come to the front?
Pool?
Make it easier to hear.
So it's going to be the foundation itself that's going to run, I said, maybe a couple feet into the drainage, the easement. I did want to, if may I add something, I apologize. So we've also discussed with our contractor, an engineer came in, does not impact any drainage, flow, won't impact any neighbors' properties from that aspect either. So we did have somebody take a look at that.
Yes, sir.
think the pool contractor has it, just to report him saying, from their point of view, it's not going to impact any flow or drainage.
I would recommend that you go to your contractor and get a copy of that from the engineer. And I would also make sure you've got a copy from HOA. These are just statements that I'm making for your good, not for mine or for this
I
board.
do have actually the HOA's approval. We do have that.
Do they have a letter from you accepting responsibility?
Yes, they do, yes.
Yes, sir.
It's a swell and a pipe. I think there's a from what I understand, it's about an 6 to 8 inch drainage pipe that is in that swell. For 20 feet, that encroaches on, again, our property, the way it's shaped, just to give you a little bit of a layout, it's in the middle of the property, but one half of our property is on an incline, makes that part somewhat, the kids can only play on a hill so much, instead of flat ground, so it does limit the things we can do on the property. Say that again, I'm sorry. Yeah, our pool, the guy who's, the company's building the pool, told us that it would not impact anything in that respect. Correct. They're people, whomever they are, I'm assuming they're, maybe that's a wrong assumption on my part, that was an actual engineer, but the pool company who's done this, been in business for.
Who prepared this drawing?
I'm sorry, sir?
Who prepared this drawing?
I forgot the.
Who is the contractor?
Dead-Eye Pool? What is it? Dead-Eye Pools.
Okay.
Correct.
Having spent 50 years in the construction industry, whoever done that drawing knows what he's doing. He knows how to make a drawing. I don't know whether he can install a pool or not.
Let's hope so.
No, it's just the back, the back of the pool, I guess, and the stairs.
Yeah.
See that small, that's what I take it, that it is. Because
Correct, yes.
on the other end, that's just grass. Because there's no patio going on the back side of it. Do you know what I mean? No. Oh, okay, right, yeah. Okay.
Yeah.
Well, right, I guess it's going to be travertine then, like the overlay of the,
The patio itself.
the patio itself behind it, I guess. You can't have just grass. So it's not really the whole, it's not much of the actual structure of the pool.
That is yes, we have a patio already there, a paved correct, yes. That's why we couldn't be closer to the house. No. Correct.
Right.
It starts where the patio ends.
They tried to make it as close to the patio as they can, so,
Within all code and
yeah.
applicable laws.
Okay.
It's very
Yes, sir. Yes, sir.
custom built.
Yep.
Pretty small, 10 by 27. 10 foot wide
Yes.
by 27.
Yes, I believe it is. Is it? No.
No.
right over here.
Oh, well, yeah, it has, on the back side of the pool, into, like, it's going to be built into the pool, it's a 2 feet, like, wall. They think that will, the contractor thinks that would help too with the drainage, that there's a little, that we don't just put patio all around it on the backside, that we put a 2 foot, it's only 2 foot, yeah, I guess you would call it kind of a retaining wall, but it goes into the pool, you know? It's like the back part of the pool. And he thinks he thought we should do that for drainage, that would be better.
No.
No.
Yeah, it'd be all in our property itself. There's no impact to the neighbors.
Right.
From what we understand, there's a drainage pipe there, yes.
The contractor or whoever came out, they believe it's in the middle, where the,
Where the zero mark is? No.
yeah, he believes it's in the middle.
Well, yeah, it's 10 feet
Yeah,
on each
10
side
feet on each
of the
side.
pipe. So you just have to cut the easement in half is where the pipe is.
HOA should actually have a drawing showing, a site drawing showing where that pipe's laying in relation to the house and the property line.
We had tried to hire a lawyer to look into that for us. I didn't have much luck. I don't know, how to see where exactly the pipe is.
There's a number of people have got plat drawings showing the distance of that pipe from your property line and from the street and everything
Right.
else.
I guess
The developer, the site developer, the homeowners association, they should all have copies of that drawing.
Okay. Yeah, we could get that from them and give it to our contractor. He believes that,
It's a dead smack in the middle.
he believes that it's where, he believes he knows where it is and that they're not going to go near it.
The way the swell's built, the pipe location actually is irrelevant, but it would be good to know where it's at in relation to your house.
So we get that from the HOA.
Yes.
Right.
Or the developer. Somebody's got a site property showing where that pipe's laying.
Okay. Yeah,
People that installed it can tell you where it's at. All right. Anything else for the applicant?
So
Yes, sir.
the pipe, do we know where it comes from and where it goes, what feeds it and what it feeds to?
Well, I think based on the Sugar Creek is where it empties out, and it runs along, the backyards of the houses on our street.
Okay. Anything further?
Attachment 7 to your staff report is the stormwater pipe plan for the whole subdivision.
That's what we're,
Where it's going from, it goes from the road back through the neighborhood to Sugar Creek.
that's what I've been referring to. Where is it at? It's in my packet.
Should be attachment 7.
See, we just got these tonight. It's irrelevant. The swell is the problem. If you block a swell, you're gonna get water. If you don't block a swell, water is gonna stay in the pipe. Any other questions for the applicant? Hearing none, do we have questions for staff? Thank you, sir.
Thank you.
found that. Now, it is given a dimension, but I couldn't tell you what it was if I wanted to. Right?
Yep.
That's from the ESP. It may or may not show that pipe.
It just
But
went,
the pipe itself,
I'm trying to pull up the larger document so we can zoom in on it if you'd like. Okay. So this is from the agenda, the online portal, if anybody that's watching wants to follow along. This is document 7 under the report. This is the overlook at Barber Rock. This is the preliminary plan showing the dark lines here are the easements for the stormwater. It was not done in one piece. It was done several different places. And the final plat that we have that's in your packet it just shows the easement. It does not show the actual, but you do have this in your packet as well. Yeah. The property that's in question is the one here. And it does have the location of the easement on the plat.
okay.
This subdivision was done in many phases, so there's not one central map showing how all of the drainage went together except for the preliminary plat, which is what they would have been approved upon based on that with the planning commission, and that would have gone forward into construction.
If it's got an 8-inch pipe in the ground, it's gonna be relatively deep, and the swell's the problem. And the pipe itself should not.
In addition, thank you, Ms. Cato. Ms. Cato reminded me that the county did not have a stormwater division at the time that this was approved. This was DHEC.
Right.
Which might be why we can't find the as-built as much as I would like to find them. We have some of them, but not all of them.
Okay, we got any other questions for staff? Yes, sir. True.
You mean the pool? Or the swell itself? Sure. At the applicant's expense, absolutely. The one thing we have to double check on that is if it's in the flood zone. If it's in the flood zone, you can't move it into that area. And I can check that real quick.
But he shouldn't be in a floodplain. I mean,
Yes.
you can do that, but
It does back up to Sugar Creek, but not this particular lot. This particular lot doesn't back up to the Sugar Creek. Yeah, Sugar Creek has a heck of a floodplain. Beg your pardon. Sugar Creek has a significant floodplain.
Sugar Creek was a mile wide.
It does not have the floodplain on that property. The floodplain surrounds the neighborhood, but this particular property is not subject to that. So as long as the plan to move the pipe can be achieved and approved by our staff, since we now have jurisdiction over the stormwater issues in this area, then it might be possible.
But not to move the pipe.
No, the easement, the easement is for both the swale and the pipe, as far as I understand it from our conversation today. The easement has to cover the pipe. If you're moving the swale and the easement, and you're not moving the pipe, then you may not make a difference here. Right. Yeah. So the 10-foot on either side of a 6 to 8-inch pipe is for the equipment. So you can get a 20-foot piece of apparatus through that area. Right. Yeah. Not being an engineer, I can't tell you for sure, but if you want to defer this to give them time to evaluate that as an option, that would be one of your options as the board. I would make sure to check in with the applicant to see if they would like to look at that as an option. And if I may say, while I'm up here for the record, I apologize for whoever told you that Lancaster County doesn't care about the stormwater easements. We do. Even though they're private, they're part of a conveyance of water from the public street to the water, to the river. And the county doesn't maintain the system. The HOA does, but we depend on it to work in order to keep flooding from other places. Thank you for letting me say that. I feel so much better. My CFM is intact. I'm sorry, I'm a certified floodplain manager. I have to say that.
All right. Anything else for staff? Hearing none, thank you, Ms. Harden.
You're welcome, sir.
Gentlemen, it's time for discussion among yourselves, and that's a good time to throw stuff or talk about it or whatever you feel like you need to do.
It's on now, right? Just that same question, if they're willing to go that route, spend that money, get that looked at. It may work, it may not, but it'd be an option.
It's actually an extremely good question, in my opinion. And I'm sitting here with people that know as much about this as anybody in town.
People here that know more than I do, obviously, but
But I'm not the homeowner. But I would, in this instance, probably get me a good engineer with a drawing that shows where that pipe's located, check that swell and see. A good water engineer will tell you what the problems will be in the future, what they are now, and what they won't be. But I've built around a lot of this stuff. I have built in it. I've built around it. I've built on top of it. And it is not an easy thing to do sometime, but if you you got the right people, it can happen. Yes, sir.
I would say that, yeah, I do support staff's position on this, to support the code here, that there should be no structures, improvements like when they're filled within that easement. Now, that being said, though, you know, of course, I don't believe the board here is to solve a problem. It is to, listen to the variance request and so forth. But
Right.
hearing that if the applicant did, maybe obtain the services of an engineer to evaluate the possibilities, could it be rerouted, and if so, if it could be both the pipe and the swale could be rerouted. If and the parcel is replatted to show the newly recorded easement and so forth. That's something I could see as a viable,
Right.
way to move forward.
I have to agree 100% with that. And of course, it would take somebody smarter than me to figure it out for him, but. Anything else? But that would be one suggestion that could be made, and if they're willing to go that route, that's up to them, and we can, if this is continued, would you mind coming back to the podium? This is a little bit unusual, but I'm going to ask you.
Yes, sir.
If this case were continued, I hate to see it denied, and we're not fully enthralled about approving it. Would you have the access to possibly see if there is a way to get you around this problem without us denying it tonight? And I'm not saying it would be denied. There's 5 people at this podium that's going to vote. I'm speaking for one.
So, to go the route of hiring somebody to take a look at possibly repositioning this well. I mean, yeah, we're willing to look into it deeper.
Look into it.
Absolutely.
We don't really know.
We do have a budget.
Yeah, we have a budget. We don't know what that would, and
Moving a
all
pipe
that
and a swell,
entails, so, and we do, we do have a budget, so, but we definitely would ask.
Yeah,
Look
I mean,
into
I
it.
misspoke a little earlier. I thought our pool contractor was somewhat of an engineer, so I took his word for, of him telling me that.
And I'm sure that if he's willing, he could probably step in and help you some with that, but that's up to you. I'm not telling you what to do.
Sure.
I'm just making a suggestion. I'm just telling you what I would do if it was mine.
Understood, we appreciate that, but we are willing to
If
explore.
I wanted the pool bad enough, I'd get it. One way or the other, what it would cost.
I mean, would not another option maybe to modify that existing patio and trim back some in order to pull the
So
pool back?
that was something we have discussed. We do have some other, we have an overhang and columns that hold up the patio, so we couldn't go into the columns of the patio. And then we have some other structures that's permanent.
He has a pizza
I built
oven.
a pizza oven by bare hands, so I told the pool guy if he touch it, there's no business for him, so. So that limits, to answer your question, sir, it limits the ability of going into the patio.
Right. Thank you.
Thank you.
I think you answered our question, so. Gentlemen, do you have any further discussion? If not, I need a motion to bring this vote to the matter of the criteria.
I make a motion to approve.
We have a motion from Mr. Mullen to approve. Thank you, Mr. Bangle. A motion and a second to approve. If any of the four variance criteria are denied by a majority vote, the variance will be automatically denied. There will be a roll call vote on each of the four criteria, and that begins. Are you ready? Now, item number one, the zoning variance requirement or criteria, that there are extraordinary and exceptional conditions pertaining to this particular property. Do you agree or disagree?
Charles Deese,
Agree.
James Falconberry,
Agree.
Mark Boland,
Agree.
Aaron Fender,
Agree.
Joshua Pengel.
Item number two, that these conditions do not generally apply to other property in the vicinity. I disagree because there's several properties in that area that are involved in this same particular system.
Charles Deese,
I've already stated.
James Falconberry,
Disagree.
Mark Boland,
Disagree.
Aaron Fender,
Disagree.
Joshua Pengel.
5 members voted to disagree on that particular item. Number 3, that because of these conditions, the application of the ordinance to the particular property would effectively prohibit or unreasonably restrict the utilization of the property.
Charles Deese,
Agree.
James Falconberry,
Agree.
Mark Boland,
Disagree.
Aaron Fender,
Agree.
Joshua Pengel.
It's a 3-2 vote. Last item, that the authorization of a variance will not be of substantial detriment to adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance.
Charles Deese,
Disagree?
James Falconberry,
Disagree.
Mark Boland,
I disagree.
Aaron Fender,
Disagree.
Joshua Pengel.
If any of the 4 variances are denied by a majority vote, the variance is denied. Item number 3, there was 3 for, 2 against, so that carried. The rest are all unanimous, so the variance would be approved. No, I'm sorry. It failed.
It failed on criteria 2 and 4.
Right. 2 and 4.
Against, yeah.
Those were both against the variance, so. I was looking at 3, a split vote, but it's my fault, excuse me. But the variance has been denied at this point. We will prepare an order formalizing the decision, and the order will be issued to the interested parties within 30 days. We have no further items to hear this afternoon. Is there any administrative? She's in the back. Is there any administrative items that we need to hear? Hi, Jennifer.
Allison's busy. I'll just comment on next month's agenda. No cases have been submitted for the agenda, so Allison may consult with the chairman to determine if there's any training or other matters that might need to be held at that meeting. But as of right now, we have no cases for January.
The way I went through this criteria tonight, I need some training. I've been lost all evening. Gentlemen, you have got a pile of paperwork that we are basically through with. I don't know what you're gonna do with yours, but I know where mine's going. Every bit of it. Look at it. And except for that little bit on that last case, this is all one. Y'all get that? I don't need that anymore. I've done read it 4 times.
As far as administrative announcements, you've already talked about whether we have cases or not coming up? Okay. Do we have any?
We have none that have been filed.
Okay.
We'll have to discuss anything.
Thank you. You'll notice that we have extra people at the dais. And that's because zoning is going to be taking over BZA from the planning side of planning and zoning. And so Shannon Cato, our zoning administrator, and her staff are going to be here on a regular basis to answer your questions. And Micah is going to be doing the minutes starting in January, excuse me. If there was a meeting in January. If we don't have a meeting in January, then they'll start whenever the next one comes.
We do have a meeting scheduled.
We do have a meeting scheduled, correct. And that'll be up to y'all to decide to. We're going to have a meeting. Okay, never mind. Michael will take minutes at the meeting. That'll be fantastic. And I appreciate the zoning department for stepping up and helping this. Tomorrow we have another UDO meeting for the subcommittee with the council members and some stakeholders. We are discussing Chapter 2, which is the one about where your zones are and what the basic requirements are, and what's called the character overlays. There's a proposal in the new UDO that is based on some information from the comprehensive plan that when you have a rural zoning designation, that right now, if it's in Indian land or if it's in Kershaw, it has the same rules. But some of the things that the rules are in some of the rural designations in Indian land are not as helpful to the system, like no curb and gutter, no extra parking and that like. And some of the things that are required in the Kershaw area are almost a hardship in some of those areas, like requiring a paved road for a subdivision of more than 4 lots. So we are looking at tweaking what you would be required based on where you are and the infrastructure needs in your area. We're getting mixed return signals on that, so that may be that it may end up being integrated into new zones in different areas. It may be a great thing, it may go away. Not quite sure how it's going to go, but staff will work with them on this. And I think that's all I've got as far as announcements. Do y'all have anything else? I do want to thank the staff. We had a violation come up in the southern part of the county that ended up having a lot of particular challenges to it that could have come either before you or just gone straight to court. And the whole staff, part of the technical review committee, is working together to try and help this project become compliant instead of having just going in and sending out tickets. And I just want to publicly thank them for their flexibility on that. We are working with the customer rather than against them. And it's been very, very refreshing.
Thank you. And speaking of meetings, does everyone still have their schedule? And I'll I'll ask this question again. I've asked it a number of times. Do you, as a board member, oppose my request that we meet on every meeting night that we're supposed to, unless it's a vacation day and has to be changed? And I don't have any vacation days or holidays, I might change that word. The closest thing we came was Labor Day, and it was not on, we're on the 1st and it's on the 7th. So. Is there a problem with, I have a reason for it, and I've explained it before. I don't mind doing it again. The night's early. We, in the past, have had a terrible problem of having enough people for a quorum so that the meeting could actually take place. They asked me if I would come over here and help them. I don't know how much help I can be, but I'm here because they asked. My first question was, why are they not having meetings? Well, they don't have a case. What difference does it make? You've got a set of minutes that have to be approved. I don't like to approve anything on a telephone. In fact, I refuse. I won't approve it. I won't even approve my own check. Telephone, they got to show it to me. But if we are in the habit of coming on the first Tuesday of every month, then it's easy for me to look at the calendar if somebody else wants to have a meeting and say, I can't come that day, I've got a meeting. And it's worked well in the past. I've done it with the Planning Commission. We met every single meeting, never missed one. And I was there for a long time. It's not bragging, don't think that for 30 seconds. But I don't think we failed to have a meeting in the whole 17 years that I was there. And I was chairman for 17 years. So it, and I actually started the work session, so we'd have 2 meetings a month. We don't have to do that here, simply because we don't have anything to work on. When those cases come to us, we study them, we look at them, and we make our own decisions sitting right here. It's not something we got to go out in the field and walk around and look at the properties. You can do that online if you wish. But if you have an objection, I would like to hear it, because I'm not here to run the show. I'm just here to kind of halfway try to line the thing up. I don't do very well at that sometimes. This guy does. He helps me a bunch. He reminds me. I had another good vice chair that done the same thing in the Planning Commission. If it wasn't for him, I'd have probably messed that bunch. But when we meet and how we meet is a board decision, not mine. I can call a special meeting if I want to and expect you to be here. I don't plan on doing that, but there may be a time when I'd have to. They call me and say, we've got a document ready for your signature. I come that same day. I don't care what I'm doing. I come by here and sign that document. It's me. I was born to do it as near right as I could. Mr. John Crosland Sr. explained that to me a long, long time ago. Bless his heart, he's dead and gone. So is Junior. And they were great people to work for, but they taught me a lot. I've learned a lot from the Planning Commission members, and I'm learning a lot from you guys. And all I can do is say help. the decisions. Make this one. If there's a problem with meeting every month, I'd like to hear it.
I for one support meeting every month. I see value in the consistency, and with the track record from the previous.
Well, I feel like, and I might be wrong, but I feel like that was the problem. They did not have a whole lot of cases for a while, and, you know, if you stay at home for 2 months, you don't want to come the third. But if you come every month, you've got it on your mind and you're there. And I understand, people are gonna be sick. People are gonna have special occasions like your wife's birthday or an anniversary you better not miss. But as long as we've got a quorum sitting at this counter, we can operate this business. And I believe in operating it just like a business. If it's not done, it'll go bankrupt. You can spoil it in a heartbeat. And the biggest problem with this business is people not being here. So, I hush.
I have a question.
Asked it.
So last month, when I was not here, I had no idea who to call and tell that I was not gonna be here. I tried and tried and tried, all kind of different people, and nobody could give me an answer.
Well, let's
I
just,
guess I need your phone number.
let's just say that,
We had the phone roster that was published.
yeah. But I'll be glad to give it to you again. You got a pencil? Wait a minute, I might even have a card. No, I ain't. Not in this book. But, no, that's one of the things that makes me draw it in a knot is if somebody is not gonna be here and they knew it and didn't let me know. It doesn't do anything but make me look around and see where people are. And I actually get worried about it sometimes.
I can give you a number also, and I will let you know that Micah has a plan to call everybody a day or two, either the Friday before or the Monday before, to check in with everybody. But 803-416-9392. 9392. That's Micah. Micah, this is Mr. Pringle. Mr. Pringle, this is Micah.
We got Maya and Micah. We have Harden. Don't you shake that head. I was fixing to say, Miss Shannon, you shook your head. All right, gentlemen. It's been a good evening, I think. We've done the best we can do. I'm leaving this with you people. Y'all are the ones that gave it to me. We'll give it back to you. You got some clips on there. And this is yours. I will bring it to you, if I may.
Mr. Chair,
I'm waiting on that.
there's no other business. I make a motion to adjourn.
There it come, right there. He just mentioned it. I said, I'm waiting on it.
You gotta raise their hand.
Yeah, everybody, we adjourned until